Hello, and good evening. I hope everybody is well. And good evening, Suzanne, and good evening, Billy Kershaw. Hope if I can vote drunk, can I comment stoned? Donkey Dave was mint the other night and revealed a heartbreaking tale. I unfortunately missed his live stream. I do try and get in contact and sort of like take this tit for tat off because I'm absolutely sweating cobs here, but never mind. And so yeah, it's a good evening. Hope you're well. And just to let you know, can you hear me anyway? Everything loud and clear. So what we're going to do is I watched this a couple of weeks ago, and this is the Human Rights Joint Committee, and they're doing the subject on the safety of Rwanda, asylum and immigration. Now, I did a video of this where Jill Mortimer got into a bit of hot water because she made herself look a complete idiot in it. But there was so much more going on this that was just so hilarious. So I just basically wanted to let's watch it because it's just absolutely fantastic to watch. And there was so much going off, and even right at the end, they were absolutely having kittens. There were with a few of the lords who were what you would say class as Tory ones were having kittens over this ridiculous Rwanda bill, and I'll let you know who the witnesses are. I was going to say the witnesses were. Give me a quick sec. Yeah, the witnesses were Zoe Battleman, legal director of immigration law practitioners, an association at the ILPA, Tyrone Steele. Now, he got a starring role in the video with Jill Mortimer, the interim legal director of justice, Enver Solomon. He was absolutely brilliant. He's absolutely dynamite on this, and chief executive for Refugee Council. And there's also this rather strange character. Now, I've no idea why they invited this guy called Dr. Mike Jones, executive director of 55 Tufton Street Migration Watch UK. And let's just say when he does speak, you can tell he talks out of his backside a lot. And there's plenty of argy-bargy going on with other members of the Human Rights Joint Committee. But it gets really, really weird when and so it just gets really, really weird, and there's some right fallings out, and all I can say is Joanna Cherry has a hard time keeping people under control. So we'll just basically start from here, and less of my rabbiting. But it doesn't take long to kick off.
I wonder if I might ask the first question. This bill has a requirement for Rwanda to be treated conclusively as a safe country. Can I ask you, and maybe start with Justice, do you think this requirement complies with the United Kingdom's human rights obligations?
Thank you, Chair. I mean, in simple terms, no, I don't think we do think it is compliant with the UK's human rights obligations. And I'll start by taking a step back and referring to the Supreme Court's judgment from last November. The Supreme Court was asked to look at the Rwanda policy in the round as it then was, and to make a comprehensive and indeed factual assessment of the Rwanda policy and its compliance with not only the Convention, the human rights obligation, but also a number of domestic laws here and other international treaty obligations. And it found the policy overall wanting on a number of levels in terms of the fact that Rwanda has poor compliance with its international obligations, poor understanding of the Refugee Convention, poor human rights record, poor access to legal remedies in country, the lack of independence for the judiciary and legal representatives there, its past failures with respect to other international agreements, notably non-compliance with a similar agreement with Israel some years before, and also poor monitoring arrangements. So on the basis of that, the Supreme Court was, in a unanimous decision in November, was quite clear that Rwanda is not a safe country, and indeed there are a number of risks vis-à-vis breaches of human rights obligations, in particular Article 3. So when we look at the bill itself, I think it's clear that the government probably agrees with my assessment that Rwanda isn't a safe country, and indeed the agreement, this approach would violate human rights principles and obligations. And I say this from the fact that the government isn't able to give a Section 19b statement on the face of the bill to comply, to affirm that compliance is present, from the fact that the government, as I'm sure we'll discuss later, comprehensively in a number of ways tries to exclude the courts from looking at the facts on the ground by trying to legislate this fiction that Rwanda is safe, and also as well from the fact that it attempts to disapply a number of the HRA obligations which are clearly set out. So I think that in the round my answer would be a firm no.
I suppose the government would argue that as a result of the Supreme Court decision, they've revisited their agreement with Rwanda and changed the nature of the agreement and sought assurances which allows them to justify their view that going forward Rwanda will be a safe country. What would you say to that argument?
Well, if that were the case and the government were so confident that was the reality, then they wouldn't be afraid of independent judicial oversight. That's how these things work in this country. You have the executive make those decisions, make the policy, and the courts will make that assessment. I might also refer the committee as well to the new analysis put out by the UNHCR just 2 days ago, which updated its analysis of the situation in country, in Rwanda, and again affirmed that Rwanda is not a safe country. So, and that evidence, I might add, was very, very persuasive to the Supreme Court in making its decision. It's finding that Rwanda was not safe. So I think it should attract a fair bit of weight in these circumstances too.
Great. Sorry, could I just bring you in on the question? My question was really, do you think the requirement for Rwanda to be treated conclusively as a safe country in the UK complies with
It is compliant with the UK's human rights obligations and
human rights as a safe country? Question.
What an idiot I've been. Didn't realise that I'd... Oh no, you complete barn cake. What are you, Daz? I always muck this up. Without a shadow of doubt, always muck this up. Always make a Good evening. Good evening, Susan. Yeah, my fault. I mucked it up. I always do on these live streams. I can't help myself. I make a complete pig's ear of it. But yeah, good evening, Susan and Ben Shaw, Stephen Bankier. Yeah, and good evening, Hugh and Reg Fairbairn. Sorry about that. I made a pig's ear of it because I thought I'd got it on the right. Good evening, Bill Kershaw. And I realised I've been streaming for about 2 minutes, but I just realised for some strange reason it was put on a private, and I've no idea what I was. Well, I always muck it up, but never mind. Yeah, live and learn, do better. Well, I don't know about that, Susan. I do tend to make a pig's ear of that. But anyway, this is... Let's start again. What an idiot I am. But this is basically the just give me a quick sec. This is the Human Rights Joint Committee, where it's a mixture of people from the House of Lords and people from the House of Commons. And there are, yeah, and there'll be one or two here who won't be big fans of Joanna Cherry, and that's fair enough. But what you see here is just absolute bedlam. Because, as I say, they're talking about the safety in Rwanda Asylum and Immigration Bill. And the witnesses, you'll have probably seen the video of Jill Mortimer make a complete and utter tit of herself. And there was more to it than just that. There were another Tory Baroness Mayer. She made a bit of a pancake of herself, and she got her backside ripped to bits by some of these, because, like, as the witnesses, they were talking on this. This was on the first day, the very first, where they were doing this conversation, where Zoe Battleman, Legal Director of Immigration Law Practitioners, an association of the ILPA, and there's Tyrone Steele, Interim Legal Director of Justice, and Enver Solomon, and Chief Executive for the Refugee Council. And then there's Mike Jones, a Dr. Mike Jones, Executive Director for 55 Tufton Street, Migration Watch UK. Yes, it mind-boggled as to why they'll give this guy airtime, and you'll see why he shouldn't have been given any airtime, because it was just absolute nonsense the way he was spouting. But the guy, Enver Solomon, he's having none of it. He's having none of the spiel and stick that some of these Tories that they have in here, having none of it. And so it's not just what he says, but he tears one or two Tory MPs and Lords, a new one. Yeah, absolutely. Valentine Sherman, bloody tech, yeah. Yeah, I'm a terrible shill out of Stephen Banky. Yeah, hit the like button and all that stuff. A terrible shill. Demonic Cummings, Glasses Cummings, yes. But anyway, good evening, everyone. Right, we'll get back to this, and this is where it all really, there are some really juicy moments in this, and what I love about this is you've got people who just basically have got the facts. All right, Aki's mad. Hope you're doing well, mate. Hope you good to see you. But this is where you get people who are they know what they're talking about, and it's just brilliant. And when Joanna Cherry asks this question, you get a brilliant insight into what they think about this Rwanda bill. And I'll less of my prattling on. Let's get going.
This bill has a requirement for Rwanda to be treated conclusively as a safe country. Can I ask you, and maybe start with Justice, do you think this requirement complies with the United Kingdom's human rights obligations?
Thank you, Chair. I mean, in simple terms, no. I don't think we do think it is compliant with the UK's human rights obligations. And I'll start by taking a step back and referring to the Supreme Court's judgment from last November. The Supreme Court was asked to look at the Rwanda policy in the round, as it then was, and to make a comprehensive and indeed factual assessment of the Rwanda policy and its compliance with not only the Convention, the human rights obligation, but also a number of domestic laws here and other international treaty obligations. And it found the policy overall wanting on a number of levels in terms of the fact that Rwanda has poor compliance with its international obligations, poor understanding of the Refugee Convention, poor human rights record, poor access to legal remedies in country, the lack of independence for the judiciary and legal representatives there, its past failures with respect to other international agreements, notably non-compliance with a similar agreement with Israel some years before, and also poor monitoring arrangements. So on the basis of that, the Supreme Court was, in a unanimous decision in November, was quite clear that Rwanda is not a safe country, and indeed there are a number of risks vis-à-vis breaches of human rights obligations, in particular Article 3. So when we look at the bill itself, I think it's clear that the government probably agrees with my assessment that Rwanda isn't a safe country, and indeed the agreement, this approach would violate human rights principles and obligations. And I say this from the fact that the government isn't able to give a Section 19B statement on the face of the bill to comply, to affirm that compliance is present. from the fact that the government, as I'm sure we'll discuss later, comprehensively in a number of ways tries to exclude the courts from looking at the facts on the ground by trying to legislate this fiction that Rwanda is safe, and also as well from the fact that it attempts to disapply a number of the HRA obligations which are clearly set out. So I think that in the round my answer would be a firm no.
I suppose the government would argue that as a result of the Supreme Court decision, they've revisited their agreement with Rwanda and changed the nature of the agreement and sought assurances which allows them to justify their view that going forward Rwanda will be a safe country. What would you say to that argument?
Well, if that were the case and the government were so confident that was the reality, then they wouldn't be afraid of independent judicial oversight. That's how these things work in this country. You have the executive make those decisions, make the policy, and the courts will make that assessment. I might also refer the committee as well to the new analysis put out by the UNHCR just 2 days ago, which updated its analysis of the situation in country, in Rwanda, and again affirmed that Rwanda is not a safe country. So, and that evidence, I might add, was very, very persuasive to the Supreme Court in making its decision, its finding that Rwanda was not safe. So I think it should attract a fair bit of weight in these circumstances too.
Great.
Yeah, so I found that a little bit interesting when he says that he thinks that even the government agrees with this assessment that Rwanda isn't safe. So why are they still doing it? I think it's just basically obvious that they just don't really care. It's all about winning votes for them. Well, the votes that they think they need. Who knows? But great assessment, wasn't it?
Zoe, could I just bring you in on the question? My question was really, do you think the requirement for Rwanda to be treated conclusively as a safe country in the UK complies with the UK human rights obligations?
In order to answer that, I think there are sort of two sub-questions that have to be asked. The first is Rwanda in fact safe? And then there's a second question of whether putting in legislation that Rwanda is conclusively safe breaches our international human rights obligations. So if I can tackle the first of those questions, is Rwanda in fact safe? ILPA, of course, does not operate on the ground in Rwanda. We have not conducted a fact-finding mission in Rwanda. But what we have done is carefully scrutinize the UK-Rwanda Treaty, the policy statement that was initially published in December and has been updated just last week, and also looked carefully at this new Safety of Rwanda bill. And looking at these three documents in the round, it's our firm view that the asylum partnership arrangements with Rwanda, including this treaty in its new legal form, do not meet the concerns of the Supreme Court regarding Rwanda's asylum system and the real risk that individuals would face ill treatment in Rwanda. And if I can expand on sort of 4 evidence-based reasons why. The first is that the treaty does not erase Rwanda's poor human rights record or the profound human rights concerns that remain, including that refugees have been ill-treated when they have expressed criticism of the Rwandan government. Now, the UK government provides no evidence at all in its policy statement that the human rights situation has indeed changed in Rwanda, including since the Court of Appeal's judgment in June and since the Supreme Court's judgment in November, particularly in relation to political oppression. In fact, the policy statement states that it is still working with Rwanda to address, I quote, concerns around the limited space for political opposition and critical voices, and that, again, I quote, UK government ministers and officials have regularly raised these issues, emphasizing the need for more open political space. This would suggest that the Supreme Court's concerns regarding political repression in Rwanda remain unresolved. There's also been new evidence since the High Court's decision in mid-2022. For example, Human Rights Watch's Events of 2023 report was very recently published this month, And it begins, I quote, with the following comment: "Commentators, journalists, opposition activists, and others speaking out on current affairs and criticizing public policies in Rwanda continue to face abusive prosecutions and forced disappearances, and have at times died under unexplained circumstances." And this is all before the Human Rights Watch report goes to discuss Rwanda's military support for the M23 armed group in the Eastern Democratic Republic of Congo. BBC also reported 5 days ago that Burundi has closed its borders to Rwanda after accusing its neighbour of funding rebel attacks. In his September 2022 annual report, the UN Secretary General highlighted the intimidation and harassment against a Rwandan refugee living in Australia following his engagement with the UN Working Group on enforced and involuntary disappearances. The Home Office's statistics, as we all know, also show that 6 individuals seeking asylum in the UK who were Rwandan nationals have been granted since the Memorandum of Understanding was signed in April 2022. The second reason is the monitoring mechanisms in the treaty are wholly insufficient to guard against refoulement. There is no requirement for the Joint Committee to act on recommendations of the Monitoring Committee, and its own recommendations are non-binding. Monitoring remains undermined by the Rwandan government's suppression of criticism, and the treaty, in fact, requires some complaints to be made directly to a representative of the Rwandan government. The treaty also provides no interim injunction process, only in the event of its breach, only lengthy arbitration proceedings. And so fundamentally, our Supreme Court's concern that, and it says at paragraph 93 of its judgment, such arrangements may be capable of detecting failures in the asylum system and over time may result in the introduction of improvements, but that will come too late to eliminate the risk of refoulement currently faced by asylum seekers in Rwanda. The third, just to very briefly touch on them, the third and fourth issues are this. The third is that the mere existence of a treaty with Rwanda does not ensure that Rwanda will comply with these bilateral agreements, when Rwanda has in the past, according to our own Supreme Court, failed to comply with its multilateral treaty obligations, including under the UN Convention Against Torture and the International Covenant on Civil and Political Rights, in addition to the principle of non-refoulement in the Refugee Convention. So if we are correct that there remains a real risk of refoulement, then it's crucial to note that neither the UK treaty nor this bill secures any suspensive legal remedy under Rwanda's legal system or under the UK's legal system if an individual is in fact removed to Rwanda and faces refoulement or ill treatment there. But it bars our courts and tribunals from even contemplating this possibility. The fourth and final point I wanted to make is that signing a treaty with Rwanda does not engender a culture of appreciation or understanding of obligations under the Refugee Convention, particularly when Rwanda has been hosting refugees for so many years, and this appreciation understanding has yet to arise.
Wow. I just saw somebody, I just saw from Eric Davis. Yeah, she's been waiting for this chance. Yeah, I think I can't agree with you. She came with all the receipts, didn't she? She wasn't going to mess about. And I'm just trying to think what Joanna Cherry's thinking there. Yeah, she was. She was absolutely excellent, wasn't she? Good evening, Alistair Cairn. I hope you're well. Good to see you here. And yeah, this is all very interesting stuff. Seems Rwanda are getting cocky. Well done, Tories. See what you've done, messing with these people. You're giving them ideas about above their station. But yeah, totally agree. But Ben Shaw, she just got a proper mic drop moment. Boom, there, have it. Something tells me we won't be far off from our Jill Mortimer's brain fart moment. But yeah, oh dear. But yeah, is it Baldrick's plan that the promiscual is telling us he's following? Yes. Yeah, stand up, girl, flick your locks and ride off on a white Charger. Absolutely. Wasn't she brilliant? Yes, totally fantastic. I'm sure this is...
Thank you. Now, Jill.
Oh, dear.
Just come in. You're both very adamant that Rwanda isn't safe at all for refugees and asylum seekers. So can you explain to me how comfortable you are then with the UNHCR using that as its emergency transport mechanism base for refugees and asylum seekers, and for indeed even funding scholarships for refugees to attend Rwandan universities?
I mean, I'm happy to respond in the sense that the Supreme Court was happy with the UNHCR's evidence, and that's our domestic court taking that factual assessment. So in terms of the UNHCR's quality of evidence, I think if it's good enough for our Supreme Court, it's good enough for me.
That's not the question. I completely agree that the Supreme Court looked at the UNHCR evidence and it had to apply that evidence under previous case law. It had to give it the proper weight. What I'm asking you is how comfortable are you that the UNHCR use Rwanda as its base? They fly asylum seekers and refugees there in great numbers. They use that as their base for their emergency transport mechanism, and indeed they even fund scholarships for refugees to attend Rwandan universities. If it is so unsafe, how comfortable are you with the fact that the UNHCR do that?
Well, Justice isn't a refugee charity, and we don't work in countries, so our kind of assessment or view on, we don't have a view on the UNHCR.
Personal view, do you know, how comfortable are you that they are doing that when you think it is so unsafe?
I'm happy to come in if you don't mind. So I think there's two things here. I think the MEDP, the Migration Economic Development Partnership, and remember that was the judgment, the Supreme Court judgment was looking at that agreement, is wholly different than the arrangement that the UNHCR has to house refugees in Rwanda affected by the war in the DRC, the Democratic Republic of Congo.
Libya.
And Libya.
People who have migrated to Libya.
If you just let me finish, in relation to regional conflicts and its operations there. That is a different arrangement, refugee arrangement, than the Migration and Economic Development Partnership. The two, I do not think, are comparable because they don't involve a individual sovereign state receiving people that have come under the UN Convention seeking asylum and then them being transferred under agreement, in this case the MEDP, against their will to then be put through a different sovereign state's asylum system. That is a wholly different arrangement than the arrangements that you are referring to. And given that, I don't think they're compatible.
But it's still a fact of whether it's safe.
But you have to accept my point, don't you not, that those two arrangements are entirely different, and therefore they are not compatible.
But there can be arrangements that are safe in Rwanda.
The two arrangements are not the same, and therefore are not compatible. You're asking whether Rwanda is safe, and I want to quote to you documents released on Thursday by the government, a whole evidence pack, and I quote from them. They say, while Rwanda is now a relatively peaceful country with respect for the rule of law, there are nevertheless issues with its human rights record around political opposition to the current regime, dissent and free speech. That is the conclusion of the British government's assessment in its own evidence pack published on Thursday. And just in addition to that, I would reference the fact that there have been individuals that have come to the UK, and Home Office data shows this, from Rwandan nationals applying for asylum in the UK, and their cases have been assessed by Home Office decision makers, and they have been granted asylum in the UK. And I think that relates to that comment and conclusion in the evidence pack published by the government last Thursday.
Thank you for your very comprehensive answer, Mr. Solomon. But the question I was asking was not if Rwanda was safe. It was your level of comfort with the UNHCR putting, refugees into their universities. They clearly think it's safe if they're giving them scholarships. So how comfortable are you with that? Not having a discussion about whether it's safe or not.
No. So I
think comfortable you are with.
I absolutely think that's a legitimate question, but my organisation does not operate and provide services for refugees in Rwanda. That's a question you should ask the UNHCR. The point that I'm making from their expertise within my organisation is that arrangement is a different arrangement that is not comparable to what I've explained is the externalisation arrangement under the MEDP. And our assessment of the externalisation arrangement under the MEDP is that it's not an appropriate arrangement and is in breach of those individual human rights. You'll have to ask the UNHCR if they are comfortable with their role.
Okay.
No, their role is legitimate in the way that they play that in other nation states across the world.
I think it's a question well made and a question well answered, and
It wasn't.
yeah, point well.
Well, it wasn't actually. She just, to me, it just looked like she would just think she had a bit of a zinger, and it just didn't materialise. And all I could hear in the background was toilet flushing as a zinger was just sort of like disappearing into nothingness. It was kind of a question that, are you comfortable? What's it got to do with him? What the UNHCR are doing? If they've got the go ahead to do it, then what's the problem? I'm wondering. But she's just pathetic, isn't she? I just couldn't help but laugh at her.
Well made and a question answered.
Thank you, Chair. Can I ask
Then Bell.
if I may, particularly arising out of the exposition, thank you very much, and the other witnesses for coming to the committee today. It's very helpful to have your advice. You may know that the Joint Committee is also currently carrying out an inquiry into atrocity crimes and the way in which we deal with the consequences of those crimes. And it's been on my mind, but of course I visited Rwanda in the aftermath of the genocide there when 1 million people died and saw the mass graves. And as recently as this morning, at a roundtable I chaired here in Parliament, a witness said that there are still 5 genocidaires who were complicit in the Rwandan genocide who are here in the United Kingdom and who have not been deported back to Rwanda because it would not be safe to do so because of the risk of torture. Now, there's an inherent contradiction, obviously, in this and in the bill that we have before us. And it touches really on the question you've just been asked about safety. And this is not about the United Nations, this is about United Kingdom policy. And I wondered if you might respond to that and how you see this contradiction, not creating people who were involved in the genocide and yet who could, we're told, be at risk of torture.
Who would like to take that? We'll maybe have a volunteer to take it. Who would feel most comfortable answering that?
Zoe, because she was very close to.
Thanks, Zoe.
I can perhaps start an answer, which is that, as I would say in relation to Ms. Mortimer's question, the real question is for the United Kingdom, what does its human rights and other international legal obligations require of it? Not what other states require of them, not what international organisations may have as their legal obligations, but those of the UK. And if removing, extraditing, deporting any individual to another country would breach the UK's international legal obligations, ILPA would say the United Kingdom should not do so in breach of its obligations. It has signed up to an international rules-based order voluntarily, and it should not seek to undermine that.
Thank you very much. And did you say that your colleague might want to add something to that?
I have nothing further to add.
Well, can I bring you in now, just conscious of the time?
Thank you, Chair. I know that the government probably say that we shouldn't worry about the Supreme Court decision because of the treaty and any additional measures they've put in place. But I just wanted to understand, having looked at the Supreme Court decision, what it would take to make Rwanda a safe country. How long would it take to make them a safe country? Who should we be listening to on this issue? Who should the government be taking advice from as to whether or not it's safe? And even if it was safe, would that be within the law, international law, to be able to remove people to it?
Yeah, totally agree. That great message there. She's awesome. Yeah, she's really, really good. And I've just remembered later on, she had a go with the clown sat side of her. Because I think he was telling one or two little porkies, and I think she basically asked him to correct the record. He's from Migration Watch, 55 Tufton Street.
Can I start, perhaps? Sorry, Mike. I was just going to say, in a way, I feel that my colleague, Mr. Steele, has already answered that question, insofar as it should be for the courts to re-examine the matter on the basis of up-to-date factual evidence from the ground and see whether it's convinced that these new safeguards and guarantees, including in the treaty, in addition to any new evidence the government or anyone else may wish to put before it, and reassess, is Rwanda in fact safe now, or is it purely a legal fiction as it is in the bill?
Dr. Jones, did you want to come in there?
Yeah, sure. That's a really interesting question, and it sort of circles back to the opening question. You know, is Rwanda a safe country? You know, what impact does this have on human rights? There's a misconception here that the purpose of the Rwanda bill is to undermine the authority of the Supreme Court. If you like, reinterpret the Supreme Court's decision. That's actually not true. It's the complete opposite. The Rwanda bill is based on the Rwanda Treaty, which was signed in December of 2023. So the purpose of the Rwanda bill, or the Rwanda Treaty, was to actually respond constructively and intelligently to the decision made by the Supreme Court. So it's the very opposite of what the chattering classes are talking about. And it essentially addresses the human rights concerns, and the core issue here is the principle of non-refoulement. The Rwanda Treaty basically makes it impossible for the Rwandan government to deport anyone to their country of origin, to an unsafe country. So if the Rwandan authorities really do want to deport an individual, whether for security concerns or they're unimpressed by their asylum application, they have to send them back to the United Kingdom.
Does that in itself make Rwanda safe?
I think we had quite a lot of evidence at the beginning about whether or not it's safe. But I just want to pick up on what you said there, Dr. Jones, because you said its purpose is not to undermine the authority of the UK Supreme Court. Yeah. But many lawyers argue that its purpose is to undermine the authority of courts across the United Kingdom, in my jurisdiction of Scotland as well as England and Wales, by taking away from them the right to assess whether Rwanda at a point in the future is in fact safe. The UK Supreme Court made its assessment at the end of last year. But this bill, I put to you, that arguably undermines the authority of all our courts in the UK because it prevents them from assessing in the future whether it is in fact the case that Rwanda is safe. And that's a factual exercise that would more normally be carried out by a court than by a government. Not right?
I think it's very much the opposite. I think, if anything, it reaffirms the authority of the Supreme Court, because the Rwanda Treaty, which James cleverly signed in December, actually addressed the specific concerns of the Supreme Court in terms of refoulement. There are also measures there related to the monitoring regime and the appeals process. So obviously the appeals court now has to have one judge from Rwanda and one from the Commonwealth. So what the treaty did is it actually changed the facts on the ground. So the purpose of the Rwanda bill is to build on the treaty and to remove any ambiguity as to the implementation of the Rwanda plan. So I would argue the opposite.
I hear you. Baroness Lawrence, I think you wanted to come in next, and we are going to have to move on to the next question.
Yeah. Dr. Jones, you were saying that during the treaty, for Rwanda to think that it can deport anybody to any other country because they signed that treaty, who's going to be there to monitor what it is that they do? Because once the refugees in Rwanda and whatever happening within the country, and they've decided, because once the people are there in the country and they've decided, well, we're going to move on and send people to X, Y, Z, but you're saying the treaty will stop them doing that. But who's there to monitor that, to make sure it doesn't happen?
That's a really good question. I mean, obviously we'll have people there monitoring it, but even before...
From the UK, I mean.
Yeah, of course. I mean, even before the treaty was signed by the Home Secretary, it was very, very difficult it would be very difficult for Rwanda to deport anybody to their country of origin. And this point was made in the Court of Appeal by Lord Burness. He said, most of these people have destroyed their documents. They're being sent to Rwanda with British documents. And Rwanda does not have the bilateral agreements in place to actually deport these people to their country of origin, so that it would be very difficult for them to violate the principle of non-refoulement. But now with the treaty, it's set in stone, and it's just easier for the Rwandan authorities. Are they going to, deport somebody to Iraq or Afghanistan where there may be issues there, or they can just send them back on a flight to Heathrow? It's a simple solution for them.
We are going to revisit the issue of the safety of the legal panel that are coming next. So I'd just like us to move on to some of the other issues. But Helena, I will bring.
I was just going to ask Dr. Jones a question, which is that.
Well, Helena, I'm quite keen that we move on here because I think
from the whole issue of safety.
Let's ask the legal panel some questions about safety. But I'm keen that we move on and cover a few chapters with this panel because it's nearly 3:30 and we're a bit tight for time. Lord Delakia, can you ask the next question?
The Parliament recently passed the Illegal Migration Act. This places a duty on the Home Secretary to make arrangements to remove many asylum seekers without their cases being considered. Where would they be sent to if Rwanda refuses to take them?
Good question.
Oh, do you like?
I'm sorry about him, but I want to have a listen to that doctor. I was just speaking there from 55 Tufton Street Migration Watch. Do you believe anything that he knows what he's talking about? Do you think he's a bit of a bad faith actor? Well, anybody from 55 Tufton Street for me is a bad faith actor. Don't work for our best interests, do they?
Okay, this is a really important question. I'm glad you asked it, because if you look at the data released by the Home Office, I think on the 2nd of January, it shows that there are around 55,000 people in the asylum system who have come here either since the 7th of March, when the bill was published, or since the 20th of July, when it received royal assent. So they are tens of thousands of people, the vast majority of them, up to 50,000, who have arrived here irregularly, and under the Illegal Migration Act, they are not entitled to any kind of legal settled status in the UK. So the UK government has created a new perma backlog of people who it has in the system as we speak. Now, the vast majority of those will have arrived irregularly, and the vast majority of those would be, under the Legal Migration Act, sent to Rwanda as a third safe country. The question that arises, therefore, is could Rwanda take them? And we know from what has been said by the government to date that it's probably hundreds in the first year and maybe thousands in the second year. So there is no way that those tens of thousands of people who are eligible for removal and who do not have a pathway to legal settled status in the UK, there's no way that they can be sent to Rwanda. So that raises the question, well, where will they go? And my understanding is that they will be bailed into the community, because we don't have the places in detention, maximum 3,000 places. They will be bailed into the community, and my organisation, Refugee Council, and a number of other organisations, up to 40 organisations working with people in the asylum system who we carried out research with, are very clear that those people will be at risk of disappearing. Indeed, one organisation has already reported that up to half of those it works with has already chosen to no longer remain in contact with the authorities. Some of those will be victims of trafficking, victims of torture. They'll be at risk to exploitation and abuse, and the consequences of that are very serious. Now, that is as a result of the situation that is currently playing out, because it is very difficult to implement this legislation and make it work. And I just remind the committee as a final point, and I quote, I saw this on social media from the government and indeed from the Prime Minister, quote, "If you come to the UK illegally, you will be detained in capital letters and removed to a safe country within weeks." Well, those up to 50,000 in the system who will be eligible for removal under the Illegal Migration Act cannot be detained and removed to a safe country within weeks. So I would suggest that that claim is somewhat misleading and somewhat fictional.
Wow.
Sorry, Lord Delakia.
Just put a question to Zoe, if what, answer the same question.
Do you have anything to add, Zoe, or do you?
Yes, maybe just something very small in relation to the Illegal Migration Act. Without an ability to remove individuals to third countries with which they have no connection, the Illegal Migration Act is on the whole unworkable. If Section 59 of that Act is commenced, then only a narrow set of individuals from EEA countries, Switzerland, Albania, and if India and Georgia are added to the list of safe states, as the government intends to do, India and Georgia can be removed back to their own country. Every other national can only be removed to a third country. And the reason for that is the inadmissibility policy. That is what creates the PERMA backlog to which Mr. Solomon referred. Because these individuals will not have their protection claims considered, will not have their human rights claims considered, they will be left in permanent limbo unless there is a third country to which they can be removed. And as we all know, Rwanda is the only country the United Kingdom has a third country removal agreement with.
Thank you. Thank you. Helena.
Yes, I really just wanted to know what scope the bill is going to leave for a domestic legal challenge to the removal, if you're an individual. So I'd be interested to know what's left. If this bill is introduced, is it enough to ensure that the individual's human rights are protected? Well, I see that Dr. Jones waved at me as though he's very keen to answer. So go ahead and tell us, what scope would the bill leave for someone to take a challenge to their removal? The individual challenge.
Again, great question. I mean, the first myth I talked about is the idea that the bill is there to challenge the authority of the Supreme Court. Well, there are some people who are very bullish on the Rwanda bill, who believe it's completely watertight and bulletproofed against litigation. That's potentially not the case.
Right.
I think the legislation is intelligent. I think it's a consistent response to what the Supreme Court said, but it does not, although it does disapply aspects of the Human Rights Act, it does not disapply Section 4. So under Section 4, opponents of the Rwanda bill could make a complaint to one of the higher courts and say, listen, this is incompatible with the European Convention of Human Rights. Now, if the judges rule in favour of that, they can issue what's called a declaration of incompatibility, and Parliament can't ignore that because these are domestic courts, So that's one way in which the bill can be challenged. The second is obviously refers to Clause 4. Now, under Clause 4, asylum seekers can appeal their deportation to Rwanda. Now, if they say, I don't like Rwanda, it's not a safe country, then that's declared null and void, because generally speaking, Rwanda is a safe country. However, if an asylum seeker says, I acknowledge Rwanda is regarded as a safe country, but for me personally, due to my individual circumstances, I may be unsafe due to irreparable harm that may be caused, that claim has to be taken very, very seriously, and there has to be an evidence gathering process. And there are two opinions on this. Individuals such as Robert Jenrick believe it may lead to a merry-go-round, an attrition of legal challenges, whereas the Prime Minister believes that actually Clause 4 applies to a very small number of cases. I think he cited medical grounds as one of the reasons. I'm not going to say which side is correct on this, but it does create an avenue for appeals to be lodged, to slow down the process. It's a logjam in the system. So the Rwanda bill, although it's an intelligent response to what the Supreme Court says, there are legal loopholes and avenues for litigation there. Yeah.
We've actually had evidence from, just so that people know, we've had evidence from the Lord Chancellor, Minister of Justice, in which he acknowledges that individuals can still appeal on the grounds that they, for example, their personal circumstances would make Rwanda an inappropriate place for them to be sent to. There are different grounds, and medical is certainly included in that. Is there anything, though, that any of the rest of you would like to say on this issue about what is the implication of this bill with regard to access to the courts? One of the things that I think we take pride in Britain, that people do have access to courts when they feel an injustice is taking place or their rights are not being respected.
May I?
Easily.
I hope you'll forgive me for refreshing this joint committee's memory, but earlier, a few months ago, in June of 2022, this committee published a report on the illegal migration bill, and it had grave concerns in relation to the denial of access to a fair and effective asylum system in violation of Article 13 of the European Convention of Human Rights. And I would say that this violation of Article 13 remains. Clause 4 of the bill is not the saving measure that the ECHR memorandum makes it out to be, to prevent an infringement of Articles 2 and 3 of the European Convention on Human Rights. The ability of the Home Office and a court or tribunal to consider whether Rwanda is safe is restricted to claims based on compelling evidence, specifically relating to a person's particular individual circumstances, and that it severely limits or excludes also the ability of our courts and tribunals to grant interim remedies. The Joint Committee was also very concerned with the age assessment and age dispute process, and that people with pending age disputes might be removed to a third country under the Illegal Migration Act. Again, this concern remains because the UK-Rwanda Treaty specifically contemplates the idea that an individual who has an age dispute ongoing with legal proceedings, who's an unaccompanied child, is removed to Rwanda. The courts find that that child is indeed a child and ask for that child to be returned. And so the treaty has a specific provision in such a circumstance. So I would again say that the committee's concerns there remain live. But if you'll permit me to very briefly paint a picture of what a domestic legal challenge would look like, if you look at the Illegal Migration Act and this bill. And the reason I would do that is because you can see that this bill contains nothing really about any appellate mechanism. It doesn't change any of our law regarding how to appeal under this bill. It only says that general claims can't be considered, but individual circumstances can be considered, and a court or tribunal can review that. So let's imagine a young person, Rishi, who arrives next week on a small boat. Still freezing, he's screened at Manson, and he receives a removal notice under the Illegal Migration Act that says he is to be removed to Rwanda. He has 8 days beginning with the date of that notice to then make a suspensive claim. It also says in that notice that any protection or human rights claims that he wishes to make would be inadmissible. If Rishi says that he's a child, 16 years of age, but is disbelieved, well, the age assessment procedure won't stop him being removed to Rwanda. What can he do to stop his removal to Rwanda? Well, he can try to urgently make a claim and say that Rwanda is not safe for him. He can try to make a human rights claim, but that's not suspensive. And he can also try to make a suspensive serious harm claim under the Illegal Migration Act. But under this bill, he can only make a suspensive serious harm claim or a human rights claim on the basis of compelling evidence. So we have a new evidence threshold introduced, and that's a very vague, undefined term. In the Illegal Migration Act, we were promised a statutory instrument would tell us what that meant. That's still not been forthcoming. He can then lay out his individual circumstances, but no circumstances in relation to Rwanda's general circumstances. He can't even say that Rwanda would refer him back to his home country. And it's foreseeable that a large number of people won't be able to express themselves with compelling evidence within that 8-day time frame, particularly given the current issues in relation to legal aid. If he wants to say that Rwanda is not safe for all LGBTQI plus people, and that they would face discrimination there, and the Home Office's own country information note accepts there is discrimination of LGBTQI plus people in Rwanda, It's unclear, I would say, on the basis of the bill, whether that would count as something in relation to the general safety of Rwanda or something on the basis of his own individual circumstances. And of course, even if he is a victim of modern slavery or human trafficking, we know that the Illegal Migration Act still permits him to be removed and denies him of any protection and leave. Now, if the Home Office or the courts and tribunals do agree that Rwanda is not safe for him on the basis of his individual circumstances, that does not free the Home Secretary from the duty under Section 2 of the Illegal Migration Act to make arrangements for his removal. He can't be removed to Rwanda, but the duty still exists. If the Home Office or the courts or tribunals consider that Rwanda is personally safe for Rishi, whether because Rishi doesn't have compelling evidence or whether because it only thinks it's not safe on a general basis, then he has no domestic remedy if his Article 2 or 3 rights would be breached under the European Convention on Human Rights. Now, if he is to be removed under the Illegal Migration Act, and I started this with he receives such a removal notice, Clause 4.6 is abundantly clear. The full ouster in Section 54 of the Illegal Migration Act applies. So the courts and tribunals cannot grant any interim remedies with the effect of preventing or delaying his removal to Rwanda. So he has no domestic remedy with automatic suspensive effect, and that is in clear violation of Article 13 of the European Convention on Human Rights.
Wow. I just forgot how brilliant she was. Because I watched this a few weeks ago, I've forgotten how brilliant she was. Just not messing about, is she? Not falling for this nonsense of, smoke and mirrors with some of these Tories. Just saying it as it is, isn't she? She's absolutely brilliant. And, yes. And little Rishi, that made me chuckle.
May I ask you a follow-up then, which is, let's imagine our young Sushi, is he Rishi? Was he Rishi? Are we calling him Rishi? All right, so Rishi is 16 and he's arrived on our shores. And let's say that he is someone who suffered torture in Syria, renowned for its torture, and he has already had a breakdown because of that. And whilst he is in those days before he is due to be transported out, he has an episode, a psychotic episode. Is it possible for him to argue that Rwanda is not a safe place to go to, given that 25% of its population have mental health problems, and it's not possible for them to be adequately serviced by a system of healthcare that has only a small number of psychiatrists and even smaller number of people who are psychologically trained?
I would say it is possible to argue it on the basis of the definition of a safe country in Clause 1. So a safe country is defined as a country to which, if a person is removed, they would not face treatment there that would violate the UK's international legal obligations. And so if the argument, and it would depend, of course, on Rishi's specific medical concerns, but if the argument is that if he were to go there, he would face treatment that would either breach Article 3 of the European Convention of Human Rights, for example, then possibly, or even Article 8, then possibly such an argument could be made that Rwanda is not safe for him. But I would go back to what I said, the same thing in relation to LGBTQI plus people. I think this individual and this general is at a level of undefined sort of vagueness that us lawyers, I am sure, would not be happy with. And it will probably be for the courts to interpret these terms.
Would asylum seekers be able to bring claims in the European Court of Human Rights if they can't bring them domestically, if they're excluded from that possibility, if an ouster clause prevents that?
Certainly, yes. So the fact that Section 3 of the Human Rights Act is disapplied in relation to this bill only sets us on a further trajectory for a collision course with the European Court of Human Rights, because we cannot prevent convention breaches on a domestic level. Then we have the issue of very limited domestic remedies available. Of course, nothing in this bill and nothing in the treaty prevents a final judgment from Strasbourg, which would of course be binding on the UK due to Article 46 of the European Convention on Human Rights. So yes, we can expect claims to be made and final judgment from Strasbourg.
Jill, can I bring you in, and then Doreen?
I just sorry, jump in. Good evening, Mary McClare. Yeah, family's very well, thank you. Hope you and your loved ones are very well as well. Good evening to anybody, any late stragglers. Again, as usual, me professional to the end. You know, make a complete ball up of it. Got it, messed it up again as usual. I'll get there in the end.
Can I just come in? I think it's really important to just pull back here, because this is a critical point for the committee to understand. A critical point for the committee to understand.
I'll hear this and I'll take you.
So, Chair, I do want to make this point.
I want to hear it.
The premise of this whole conversation is that people arriving here are guilty until proven innocent. They are guilty because the Act blanketly assumes them to be illegal immigrants and withdraws their right to asylum. It deems that their right to asylum is no longer a legitimate right. In effect, it's extinguished in the rights of UNHCR because of the inadmissibility provision. So it is effectively saying you are guilty until proven innocent. The due process that we're talking about is a limited due process that gives them the opportunity to actually say, no, I'm innocent. I am an individual who the UK government should still protect within that narrow due process that the Act allows for, because it says that all asylum claims are inadmissible. This is an important point, because if you look at who we're talking about here, half of these people that we're talking about are from Afghanistan, Eritrea, Iran, Sudan and Syria. The current grant rate at initial decision for these nationalities is over 80 or 90%. So these are refugees who are being told, you are not a refugee, prove you're a refugee, even though the current system is determining them to be refugees. So they are not illegal immigrants, they are refugees. So we are in effect saying to them, no, you are an illegal immigrant, prove to us you're a refugee, even though the current system is saying to them that they are refugees.
Right.
Boom.
Jill, and then Doreen.
I'm going to be very brief because I do have to leave. I would take issue with that, because anybody who arrives on a small boat arrives here illegally. That's the first thing. But then we've heard all this wonderful.
No, they don't. They arrive here irregularly.
Forgive me, it's my time now, Mr. Solomon.
I can just intervene here. I think we have a fundamental disagreement.
Yes, so
clearly,
can I speak?
Anyone who arrives here arrives illegally in terms of UK law.
Yes.
They are not arriving illegally in terms of international law.
Well, we are in the UK.
Yes,
so
but the United Kingdom has signed up to many international treaties.
Correct,
and it's
yeah.
trite law. Any undergraduate law student knows that merely by changing your domestic law, you do not change your international law obligations. I think most lawyers would recognise that. I just want to make that point.
Well, most lawyers would
I accept your view that in terms of UK law, it is an illegal arrival. I think what Enver was saying, that in terms of international law, it's not.
Yeah.
But I think
under domestic law,
important.
They are illegal arrivals. So, but taking back, I want to strip away a lot of this academic hypothetical argument, but I will stick with Rishi, if I may, and I'll stick with Rishi, who's been tortured and he's in France about to get on a boat. Do you think that if we go back to the kernel of the intent of this bill, you know, assuming the fact that Rishi, when he's in a camp or something in Calais, will have been advised by refugee charities over there of his rights, do you think that being told what could happen to him under this bill will deter him from entering a contract with an illegal gang to go into probably some sort of slavery arrangement over here to pay for his crossing, and stepping foot in that boat and undertaking an incredibly dangerous crossing? Will it deter him? It's a yes or no, because I have to leave.
No.
You won't think it will deter him? Okay.
And I'm happy to share with you the evidence from 40 organisations that draw the same conclusion, including organisations that work with people in Northern France.
I might add also the evidence from the Home Office with respect to the value for money of the proposal and the fact that there had to be ministerial
It's not about
intervention
money,
signed
I'm
off.
just interested in stopping
Well, if it would be from the Home Office's perspective, it would be value for money if it did have a deterrent effect, but that was not what the Home Office found.
And I share your desire to stop those individuals taking very dangerous journeys and paying money to people smugglers. I absolutely share that. My argument is that this isn't the right way to stop that vile trade.
Bring in Doreen, and then I know Dr. Jones wants to.
I loved her face. Well, she got the answers you didn't want to hear. No. She's an idiot, isn't she? You just think, do yourselves a favour. I think she represents Hartlepool, doesn't she? Do yourselves a favour. Just get her out. She's a lunatic, isn't she? Not very bright, is she?
To say something.
I think it's when Zoe was talking about all the different stages of appeal that individuals have to go through in order to, I presume, around the refugee status. The question is, who pays for all of that? Because people are coming, they won't have the resources to challenge any of the things that's happening to them. So how do they get over that hurdle? Because they come in here, they've got no money, have no thing. How do they get to challenge all the different status that they have to face?
Totally agree.
So if you're able to.
Of course. The Illegal Migration Act included at a very late stage an amendment which amended the Legal Aid Sentencing Punishment of Offenders Act to allow individuals to access legal aid once they are in receipt of a removal notice under the Illegal Migration Act. Additionally, under the LASPO in any case, individuals were able to access legal advice in relation to making a protection claim. And so on that basis, individuals who don't have the means should be able to access legal aid in England and Wales. And there are also legal aid arrangements in Northern Ireland, and Scotland has more liberal legal aid arrangements than we do in England and Wales.
They will have some resources in order to challenge.
The issue is there's no legal representatives able to assist them, but that's a separate matter for a different committee, I think.
Right, okay, right, thank you.
Dr. Jones, you wanted to come in on that point. On this point broadly.
The previous
Jill's point, yes.
Yeah.
Yes.
The previous question,
Terence.
Yeah, will it work? If it goes through, amended or unamended. That's the core issue. I think potentially the Rwanda plan can work, but it depends on one crucial factor: deporting a critical mass of people. It depends on numbers. So the purpose of the Rwanda plan is to make it economically irrational to pay €4,000 or whatever it is to a criminal to cross the English Channel. Because if you end up in Rwanda, then obviously, given the differences in terms of GDP per capita between Europe and Rwanda, then obviously that's not a good use of money. Has it worked in the past? Well, Australia obviously had a similar scheme with the island of Nauru. Admittedly, there were pushback policies that took place at the same time, but the numbers went from the tens of thousands to zero within the space of a few years. Number of deaths in the ocean, zero. It worked. I mean, and it's quite funny listening to people speak here, because the exact arguments that it's expensive, it won't work, it's impractical, those arguments were made in Australia by the opposition party. The exact same arguments. And there was a big political...
A different set of circumstances in Australia, though, isn't it? A very different set of circumstances.
Well,
the solution they chose is very different from the solution chosen here.
I mean, we couldn't have a pushback policy on the English Channel.
It was contemplated, I think, but then
the jet skis, the armoured jet skis, yes. I mean, no, you couldn't have that in the English Channel because, firstly, they're not boats and they're dinghies and they'll capsize. And
pushing people back to where they came from in the sea seems to me to be very different from taking people who've arrived here and deporting them, to use your language, deporting them across the world to Africa. So they're different. Compare the two.
But the point I'm referring to is the outsourcing policy. That is similar to what we have with Rwanda. That did work, and the opposition party were against it. But when they looked at the numbers, you can't argue with the statistics. There was a bipartisan consensus. The only party that is against this policy now is the Green Party.
I'm not sure that's the case. I mean, I met with the Australian immigration minister from the current government, that's a Labour government, and he opposed that policy and explain that the critical factor was pushbacks that you couldn't adopt, as you say, Chair, in the UK channel, and the conditions and circumstances in Nauru and some of the offshoring. And it was different because it was offshoring, it wasn't outsourcing. So they remained under the jurisdiction of the Australian states when in Nauru. Here we're talking about them not remaining under the jurisdiction of the UK state. They're being passed over to another jurisdiction, the Rwandan state, and that is fundamentally different arrangements.
When I watched it first, I was sat there thinking, why is that clown here? It's just basically just. Well, we all know where the Migration Watch are from. 55 Tufton Street, and we just don't need to say any more. And pushing this Australian immigration thing that they did in. He's an idiot, isn't he? You just think, why did they invite him? It's just a complete and utter bell tap, isn't it? Oh, and you could tell Zoe was desperate to jump in once he started, when he brought up Australia. You could tell she wanted to jump in, didn't she? Oh, well said. Brilliant.
Thank you. I really will have to move us on to the next question, otherwise we're simply not going to cover the ground we need to cover today. Belle, could you?
Yeah, thank you.
Have a question.
So we've established that we are on planet Earth. The UK is a country on planet Earth, and we've signed up to international laws, which means we have to comply with them. And do the ouster clauses in this particular bill prevent the courts from reviewing any challenge to the safety of Rwanda, comply with respect for the rule of law, and do these ouster clauses have any broader implications for human rights?
I'm happy to kick off on that one. So, no, I don't think they're compliant with human rights, and I don't think they're compliant with the rule of law. And I'll give a couple of examples of the ways in which the bill attacks and ousts judicial oversight. So firstly, I think as others have highlighted previously before, the bill tries to strike out the ability of our domestic judges to consider any appeal or review to the extent that it's brought on the grounds that Rwanda's not a safe country, including claims or complaints that Rwanda will or may remove a person to another state, contravening its international obligations, including under the Refugee Convention, that the person will not receive a fair and proper consideration of their asylum or claim in Rwanda, or indeed the fact that Rwanda will not act in accordance with the treaty. That's out with the ability of the of our domestic courts to look at. And it's one of the ironies of the bill, in fact, that you have the disapplication or the kind of disregard of international law through this bill, but then this expectation requirement that, one, a treaty will fix things, and then two, that Rwanda will hold its word. There seems to be an inherent contradiction in that approach. Secondly, in terms of the limitations on the jurisdictions of our courts through these broad notwithstanding provisions that override rules of domestic law, the common law, the Human Rights Act, and any interpretation of international law by the court or tribunal. And we've already heard of the disapplications of sections 2, 3 and 6 to 9 of the Human Rights Act. The third point I think that's important to make, and others have iterated previously, is around this empowerment for ministers to ignore Strasbourg interim measures. I think that's at clause 5. And it's worth reminding the committee that interim measures, they're only used or can be issued in exceptional circumstances where there is a risk of imminent risk of irreparable harm, such as the risk of torture and ill treatment, and parties can request the European Court of Human Rights to reconsider its decision or lodge a fresh request if those circumstances change. And so there's a kind of panoply of different options that the bill operates, that the bill introduces to try and oust the domestic court's oversight. And again, I reiterate the point I made at the beginning of this committee hearing. It's not credible to suggest that the government actually considers the factual or legal situation to have changed on the ground, because otherwise, why would they be afraid of this oversight? And I think that this precedent, the potential precedent that this bill could set, speaks to wider constitutional and rule of law issues that are already pervading the country in terms of policy that's being made. And I think this bill represents a marked escalation. And I'll end, I think, with a quote from Lord Reid, the current president of the Supreme Court, in the Unison case, talking about the principle of the rule of law and the fact that at its heart the courts exist in order to ensure the laws made by Parliament are applied and enforced. People must, in principle, have unimpeded access to them, that is the courts, and without such access, laws are liable to become a dead letter. And I think that warning from Lord Reid in the Unison case is particularly pertinent today in the context of this bill.
Thank you. And just quickly, Rwanda's foreign minister actually said that without lawful behaviour by the UK, Rwanda wouldn't be able to continue with the partnership. So what would be the likely consequence for this policy if the domestic courts or the European Court of Human Rights found that it was not compatible with international law?
I can't speak for Rwandan foreign policy, but if that's the line that he's set in, our courts find that it's in contravention, or indeed it goes all the way to Strasbourg, because I think that's the point that was made previously before. The limitation of appeal rights here means that appeals straight to Strasbourg, so ignoring all of our domestic courts and going straight to the Strasbourg court, are going to become incredibly more likely. And again, I've seen nothing that would convince me that Strasbourg would take a different view from the Supreme Court, or indeed that enough factual elements have materially changed that the Supreme Court would decide differently today.
Thank you.
Thank you. Simon, do you want to come in there?
Thank you. May I first declare an interest as a barrister practising in human rights and public law?
Remember this guy? He turned up 10 minutes later for the Home Affairs Select Committee and just decided and was incredibly rude. What a Tory bell tap. Horrible little worm he is.
Practising what?
Human rights and public law.
Mm-hmm.
Mr. Steele, in your view, in the event that this bill was brought into force and a challenge was brought on a Rule 39 application by a person subject to a removal flight, in your view, and I'm interested to hear all of your answers to this question, would the European Court make a Rule 39 indication?
I mean, I think that's in terms of judicial independence, that's a matter for the court, but there would be, if there were a risk of serious and irreparable harm, then it would be entitled to do so. And I think that's the issue within this bill, is that it politicises the response to that and allowing and empowering ministers to ignore them. I mean, that doesn't change the fact that under international law they would still be binding, but I think that's the kind of political reality of what the bill would imply.
Well, what I want was your view on the evidence that you have, in your view, in relation to Rwanda and what the Supreme Court said. Do you think that in the circumstances that I suggested in that hypothetical example, in your experience, would a Rule 39 indication prohibiting a flight be granted?
Well, I think that was the case previously last summer, and so I don't see any reason why that wouldn't be the case now.
That's yes. Mr. Solomon, what would your answer be to that question?
I think it's potential, but I think unless one sees the particular circumstances, the individual case, it's difficult to make a clear and definitive assessment.
Ms. Clinton?
I agree with my colleagues. I'm sure that Lord Murray, as barristers, we don't like to prejudge what a court may or may not do. But it seems to be a real...
are paid to do, to advise on suggesting what a court may do, so that's what I'm asking your opinion on.
It may very well do so, yes.
Dr. Jones.
Well, if Section 4 of the Human Rights Act is not disapplied and domestic courts issue a declaration of incompatibility...
Forgive me, my question's about the Strasbourg Court.
Yeah, well, if they do that, then an intervention from the ECHR is much more likely, and it would give them a much more robust case for challenging the British government. But you've got to remember, if you're an immigration restrictionist and you want the bill as watertight as possible, the concern really is with the domestic courts, because from time to time nation states do ignore the judgments of the ECHR. I mean, there was one recent example. France, for example, deported an Uzbek national called MA. We don't know his full name. The ECHR said, listen, you can't do this. The French shrugged their shoulders and just went on with it. I mean, the principle of parliamentary sovereignty means that Parliament is supreme to the ECHR. Of course, there's another debate, should we be part of a transnational court? And that can get quite heated. But in terms of ensuring that the Rwanda plan works, I think the domestic courts are more important in this matter.
I would agree with you, Dr. James. Thank you.
Yeah.
Catherine. Yes. So.
Oh, this is going to get spicy. This is... Get ready. This is going to... Because she proper goes down the old... you've heard these same old sayings before, so get ready. It's going to kick off.
Given that the number of people who are crossing the channel and the number of people who die crossing the channel, it is pretty obvious that it's all a little bit unsustainable. But you believe that this bill is not going to deter people from coming illegally to this country, and it's not going to deter the human traffickers. So what do you suggest?
It's a very good question. So I think the first thing I would suggest is to not overpromise and underdeliver. I think when faced with a complex policy challenge and a complex set of international circumstances, it is incumbent to be realistic and evidence-informed in how you approach it. So the first thing I would do is not claim that there is a single magic bullet based on an agreement with a third-party state that is going to solve the problem. I would seek to adopt a multi-pronged approach based on a number of things. So firstly, it's absolutely vital to identify the criminal activity of human and people smugglers and to have an international joined up intelligence and enforcement approach in the same way that countries seek to tackle the illegal drugs trade. Secondly, it's absolutely imperative to look at providing more safe routes because otherwise, as has been clearly articulated by members of this Parliament, people will continue to make dangerous journeys. The point, I think, very pertinently made by the member of the Home Affairs Select Committee, Conservative Member of Parliament Tim Lawton, that there are many parts of the world that refugees come from seeking to reach safety in Europe and the UK where there is no safe passage. There is no safe route for them to do that. There is no mechanism in the way that Ukrainians had to apply for a visa to come to the UK. That's why my organisation is advocating the piloting of a humanitarian visa, particularly targeting countries where large numbers of refugees are coming from, such as Iran, Syria, Eritrea or Afghanistan, piloting that to see if there's a mechanism where people could apply for a humanitarian visa to come here safely and then go into the asylum process. I think fourthly, and this is absolutely critical, there needs to be a bilateral agreement with the French. And the French government have acknowledged this. The last time, many years back, when a British Home Secretary sought an agreement with the French to look at what was happening at the time, the Sangatte camp, there was an agreement that the British government would provide safe passage to a specific number of people and allow them to come to the UK. We need some kind of shared arrangement that would allow people to come via safe passage as part of a responsibility sharing agreement with the French. And finally, this is a complex issue in the way that climate change is. The majority of refugees stay in neighbouring countries. Actually, only a fraction of them come to Europe. And we need to recognise that the majority that are coming to Europe are coming from countries where there's instability, where there is human rights abuses, and unless there's a collective global effort to create stability around conflict resolution, around the promotion of rights in those countries, the numbers of refugees from those specific countries is unlikely to decrease.
You're putting some countries as a preferential to other countries, and in a sense you're saying that we have to set up a system where we should be able to accept all the people who want to come into this country, which is, in a sense, unsustainable.
No.
I think you said that we should pilot a humanitarian visa.
Yeah,
I'm presumably in the past we've had special arrangements back during the height of the Syrian crisis when we took 20,000 Syrians.
Yeah,
I don't think you were suggesting we should take everyone who wants to come.
No, there needs to be a multiple...
more safe routes.
Yeah, that's one option.
At the moment, there is this conversation in this country, both from the Conservative and the Labour Party, is that the number of immigrants coming into this country is unsustainable. We can't accept as much as we would want to. And for instance, you can look at the Gaza crisis. You can imagine, if things go badly, there will be more people who want to come.
I think I'd say two things to that.
And we need to, because you haven't really answered, how do we deal with that?
Well, I think I'd say two things to that. Firstly, it's important to keep this in perspective. The majority of refugees do not want to come to the UK or Europe.
They do, because they come through
if you just let me
Italy
finish.
and France.
Hang on a second. Can we just let him finish, Catherine?
Between 7 and 8 out of 10 refugees stay in neighbouring countries. They do not even try to come anywhere near Europe.
Can you give me that statistic
or
again,
the UK.
I missed it.
Around about 7 or 8 out of 10 refugees will stay in neighbouring countries. That is where the large refugee crises are. So if you look at Pakistan, that is where a large number of Afghan refugees are. They do not come, refugees do not come. So we need to keep this in perspective. The idea that has been put forward by some former Home Secretaries that hundreds of millions, even millions of people will come, is just not the reality. That's the first thing. The second thing is that those who do come to Europe, two things need to happen. There needs to be a mechanism to provide more safe routes, but we also need to recognise that it is legitimate for some to seek asylum in Europe under the UN Convention and to share that responsibility with our European and Western counterparts and uphold the right for them to seek asylum. That does not mean we will be inundated. Far more people apply for asylum in France and Germany and other European countries. Your final point, actually, we can't take more, I would take issue with. For many decades, including my own parents or my own family heritage, people came here as immigrants, some came as political refugees, and this country has not suffered as a consequence. This country has continued to prosper, has continued to advance, has continued to progress. And I would argue that it has benefited, from welcoming people as asylum seekers, looking at their claims fairly and allowing them to stay if they are refugees. Those refugees have gone on to contribute to our communities. My final point, the first private hospital on the NHS was bankrolled by an Iranian refugee and was opened by a clinical director who was an Iranian refugee.
I'm not saying anything against that. That was not at all
You were
my
suggesting that we can't...
Anyway.
You were suggesting, if I am correct, and correct me if I'm wrong, that we don't have the capacity to take in any more refugees.
I'm just saying that the British voters and both political parties and the European Union are discussing this issue, and everybody is trying to find a solution as to how can we control the people who come into this country. And what I was asking you, you don't like this bill, you don't think it's going to deter anybody. What was your solution? But maybe I should also
and I think I put forward a 5-point plan.
He's given us 3 answers. He said, identify the criminal activity and have better international joined-up support, provide more safe routes, as Tim Lockton pointed out at the Home Affairs Committee, pilot a humanitarian visa and have bilateral arrangements with the French. And I think your overarching point was the majority of refugees, 7 or 8 out of 10, stay in neighbouring countries, but for the 2 or 3 in 10 who come to Europe, we have to have agreements with our European counterparts about how we share them out fairly. And you made the point, which I understand is correct because I've read the stats elsewhere, that in actual fact other European countries take more than Britain per capita. And then you went on to say that Britain does have a proud history of taking all sorts of refugees and the country's not suffered, has benefited. So I think in fairness, Catherine, he has answered the question.
Anyway,
I'm very keen that we get on and cover the other.
Can we ask Dr. Jones to
yes, please,
give
Dr.
his
Jones.
opinion?
It's an absolutely fundamental question. You know, what works, what doesn't work. There are many politicians who talk about smashing the supply chains of the criminal gangs. You know, the Labour Party is big into this. The Conservatives have recently done a deal with the Turkish government. You know, there's an academy over there. There's more cooperation with the Germans and so on. Listen, this will make some difference at the margins, but ultimately it's like whack-a-mole. You know, if you close down one factory or one gang, another one pops up again. The key is making it economically irrational for people to cross the channel. Can Rwanda work? Yeah, absolutely. But you have to deport a critical mass of people. If you don't do that, it's not going to work. There are other ways of...
How many would a critical mass be?
It would have to be in the thousands. So
many thousands, really, wouldn't it?
Yeah. You know, if it's a few hundreds, the sort of cost-benefit analysis from the migrants' perspective is you know, they may be tempted, well, it might actually be worth paying that €4,000 to cross the channel. So it's all about incentives and disincentives. Of course, there are other ways of doing this. You could amend the Human Rights Act, which is the nuclear option, and you know, obviously the government are not keen to do that. They want to circumnavigate the system through the Rwanda bill, sort of disapplying parts of the Human Rights Act rather than actually amending it. For whatever reason, it's very difficult for them to go to the root cause, but that's another option. In terms of safe and legal routes, there's much talk of this, but the thing is, it's already been tried. President Biden has done this in the US. He's got a bilateral agreement with the Mexican government. The Mexicans have agreed to take people back who are there illegally in the US. And in return, Biden is taking, you know, refugees from Latin America. What happened? Real-world example, right? The figures initially plateaued, and people were like, great, this is working. A few months later, the numbers spiked. So it's actually just increased the numbers and increased the pull factor. That's the reality. Look at what happens in the real world. There's a danger of paralysis through analysis here and being too theoretical about it. Look at what's happened, look at what's worked, look at what hasn't worked. And it's clear safe and legal routes don't work.
Can I add a different solution which hasn't been mentioned? It will be 3 sentences.
Just keep it very short because we're a bit short of time.
Carriers' liability legislation is at the heart of many dangerous journeys. If the true intention...
Sorry for butting in, but somebody asked a question here. So what's Catherine's surname, please? Anyway, it's Meyer. Meyer, I think it is. Yes. And I also thought when she, after got her backside handed to her, I noticed she went straight for Dr. Jones, didn't she? Straight for back to me safe place. He can, offer alternative facts. Absolutely. Spot on.
is to end dangerous journeys, end deaths in the Channel, then altering carriers' liability legislation is the solution. If people arrive here without the appropriate visa, authorization, clearance, and we had a functioning, efficient asylum system, we could then, without the Illegal Migration Act, remove them to their country if they weren't going to face...
I missed what you said at the beginning. Alter what?
Carriers' liability legislation. That is what stops people getting onto trains, getting onto planes, and taking safe journeys.
It's not going to work with the small boats, though.
Yes, I was going to say.
Carriers' liability is not going to work with the small boats.
That would break the people smugglers' business, because there would be no business because people could get on a train.
Well, no. As I understand it, the people smuggler business blossomed because the government closed down other routes, such as people getting in the back of lorries, and that had terrible humanitarian outcomes as well. But let's leave that to one side. We have some answers on other routes. I want to bring in David because you have a question, and then I think Simon wants to.
Sorry, well, I was going to make a very simple point.
To the point I made. Okay, well, David.
Thank you very much, Chair. Dr. Jones, you just talked about root causes, and as you said it, I thought, yes, that is actually the key. I mean, we've got, according to the UNHCR, Simon will correct me as he once did on a previous occasion about the numbers, but I read recently that it's about 110 million people who are displaced in the world at the moment. Yeah. And thinking about that, it takes us back to what Mr. Solomon was saying, really, about where we've been before. And in the aftermath of the Second World War, the last time we had such a huge number of people displaced and having to both accommodate but rebuild their lives, and the international community stepped up, and everything from Bretton Woods to the Marshall Aid Programme to the creation of the Iron and Steel Community and the Universal Declaration of Human Rights 75 years ago, and the Refugee Convention in 1951. Winston Churchill took us into those treaties, those conventions, because he said the world has to step up to the plate. We have to be part of the solution. And it imposes upon us collective responsibilities. And I want to ask you first, if I may, and then I'll ask you about the convention duties, because our mandate as a committee is particularly to look at our obligations under the ECHR. But first of all, under the 1951 Convention on Refugees and the need for us to act collectively, what effect will this have on those obligations, this bill? What effect will it have? Will it be negative? Is it possible to comply with those obligations or not?
Negative.
Well, both the Court of Appeal and the Supreme Court said there's nothing incompatible with the Geneva Convention in returning somebody to a safe third country. So obviously the question isn't, is this compatible with the Geneva Convention? Is Rwanda a safe country? In terms of international conventions and humanitarian obligations, you've got to remember many of these conventions and treaties were created, in the aftermath of the Second World War and during the Cold War, and these treaties were aimed at much smaller groups of people. They were aimed, obviously, at refugees from Nazi Germany. They were aimed at refugees from the Soviet Union and the various satellite states. So many of the issues we have now, global communications, aviation that's accessible to everyone, really quick transport, and people on the move constantly, that wasn't anticipated by the people who drafted the legislation. So, non-refoulement was aimed at refugees from behind the Iron Curtain, because if they were sent back, they'd be detained, interrogated, they'd have a confession taken out of them, and they'd either end up dead or in a gulag. So these laws were created for a very different time and place, and the key question is, are they compatible with the world we now live in post the Cold War?
Well, not just the world, but our duties. Mr. Steele.
Yes, I might say I take a slightly different lesson from the post-World War II settlement in terms of the various treaties, obligations and conventions that flowed out of that, with respect to the fact that I think at its core was this recognition, or the aim to recognise the inherent dignity and value of every single human being born out of the horrors of what had happened. And I think that's when we talk about having a salami slice tactics approach to whittling away human rights for this particular group or that particular group. It's obviously in the context of the Rwanda Bill. We've seen it in the Illegal Migration Act with respect to Section 3, also the Victims and Prisoners Bill, which I think is just going into the House of Lords at the moment. There has been this consistent attempt to try and undermine and separate particular groups, especially vulnerable groups, I might add, from these overarching protections. And I think at its heart, we have to remind ourselves of the importance of that kind of inherent dignity point. With respect to the Refugee Convention as well, I think underpinning that too is this principle of global solidarity and responsibility sharing, which makes the system work properly. And I think going to the suggestions that Mr. Solomon made earlier, the multifaceted approach that would be needed to address this issue in an evidence-based manner, we have to ask ourselves, well, firstly, is international cooperation necessary and important for that? I would argue yes. And then secondly, does this bill and our approach to international treaties, to international law, make it more or less likely that other countries are going to interact with us in a productive and useful and trustworthy way? And again, I would argue that it damages that in that respect.
So, turning to the convention duties now for a moment as well, and I'd like to ask Mr. Solomon and Ms. Bandelman perhaps to answer this. We were disappointed as a committee that Suella Braverman did not come before the committee to justify her decision not to provide a compatibility statement, to give us an explanation as to why that was the case. Do you think that there are amendments that can be laid and are being laid? And indeed, we heard reference earlier on to Mr. Lawton, who was on his feet while we were mentioning him during the debate in the Commons at this very moment. If amendments are made to this, do you think it is actually possible for us to come into a place where the Secretary of State could sign a compatibility statement? And do you think that is necessary anyway? Is this a desirable thing to do? And do we need to act in concert with others who are subject to that treaty still at this time to the European Convention on Human Rights?
Well, I think it's important, if you're committed to a rights-based approach and to the Convention, that you ensure all pieces of legislation are compatible. Otherwise, what's the point of signing up to that rights-based framework, international framework or convention? So absolutely, yes. I think on the question of whether this is the bill is compatible with the UN Convention on Refugees, not the ECHR, the UN Convention on Refugees, is often confused in these discussions. It is separate. I would argue it is not, and that was the clear judgment of the UNHCR, which is the international arbiter of the convention. Our domestic courts disagreed with that. Their interpretation was different, but the UNHCR's view was very clearly that it does not. It is actually in conflict with the convention. And my final point is a very simple one, actually. And I think this goes to the heart of who we want to be as a country. I do not think, as of this day in 2024, it is outdated to want to protect someone from torture, or to provide protection to someone from human trafficking, or to provide protection from someone who is fleeing a conflict that they have been caught up in through no fault of their own. Actually, I think that is the right thing to do. And that is essentially what the UN Convention on Refugees is about. That is why we signed it. And that is true today as it was 10 years ago, as it was 20 years ago, and as it will be in 10 years' time, 20 years' time, or 30 years' time. Because that goes to the heart of our worldview and our view of a collective humanity with a collective responsibility to provide protection to victims of heinous abuses.
Thank you. Perhaps Ms. Banterman, you'd also address this.
On the statement of incompatibility point, or statement of compatibility, I would draw the committee's attention to what Lord Irvine, then Lord Chancellor, said on the 3rd of November 1997, when the Human Rights Bill, as it then was, being debated in the House of Lords, which is that where a statement cannot be made, parliamentary scrutiny of the bill would be intense. Now, for this bill, as for the illegal migration bill, as it then was, scrutiny has not been intense, and we can see from the debate that's currently ongoing that the debate is taking place in committee of the whole House. And that is different from the type of scrutiny to which the Nationality and Borders Act 2022, for example, was subjected to. So I think it is crucial and fundamental to make further inquiries in relation to the Section 19(1)B statement that we have in relation to this bill. And of course, in relation to the Refugee Convention, this bill, together with the Illegal Migration Act, building also on the Nationality and Borders Act 2022, puts at risk the very question of access to territorial asylum, and it puts at jeopardy the UK's compliance with its international legal obligations under the Refugee Convention. And I'm sure my colleague Dr. Jones will wish to correct the record at some point in relation to the Supreme Court not turning its mind to the question of Article 31 of the Refugee Convention in the way that the Court of Appeal did.
Thank you very much. Thank you, Chair.
I don't think Dr. Jones has understood your...
I don't think you really understood anything during this whole conversation, full stop. Well, Sil, I've just always thought she would just... Mara Watts, I think she's absolutely brilliant. Let him have it, boss.
Whatever your criticism.
I'm just taking a note of that. You say that the UK Supreme Court did turn its mind to Article 31.
It did not.
It
no,
did not.
That was not one of the particular issues which it addressed in its decision.
What's the point?
It didn't look at the question of third country removals and say that third country removals in principle are lawful under the Refugee Convention. The Court of Appeal did address that point. The Supreme Court, in its judgment, unless I'm missing a paragraph in which I would be very grateful to be indicated in due course, didn't consider that specific question.
We're very fortunate that the committee has legal advisors, so we can get our legal advisors to clarify that point. But Dr. Jones, in fairness, I think I should let you respond.
Court of Appeal.
Right.
Transcript.
Right, okay.
Well, as I say,
the point was unappealed, so the Supreme Court didn't disturb that finding by the Court of Appeal.
Didn't also address it.
I just, hang on a second. David, are you finished?
I'm finished. Thank you very much to the witnesses.
Catherine wanted to come in, and then Simon, but I just want to keep it really small because we've kept these witnesses much longer than I said.
Particularly to Dr. Solomon. I don't think anybody in this committee, and this is certainly not what I was intended to say, that we should not take care of people who are in genuine need of our help and who've been abused, or this is not the point. The point is the point of what we're examining today is about this particular bill, and if you don't like this particular bill, what solution would you have put forward? But it's not a question at all.
I understand, but with all due respect, the point that I'm making is the convention is fundamentally about granting protection to victims of human trafficking, to victims of torture,
not all of the people who come are victims.
No, the convention is about allowing someone who has been a victim to have a fair hearing in any jurisdiction that they choose to seek safety. That is the premise of the convention. And my point is that that is not out of date. That is the right thing to do, and that goes to the heart of who you want to be as a country. And under this legislation, the Illegal Migration Act withdraws that right because it rules all irregular arrivals, their asylum claims, inadmissible. So a victim of human trafficking seeking protection in the UK, arriving irregularly, is not able to seek protection under the Illegal Migration Act.
Simon, I think you wanted to come in, did you?
Yes, I just wanted to clarify some points on the Section 19(1)(b) statement. You will obviously all agree that a Section 19(1)(b) statement does not of itself say that the government thinks that the proposed bill is in contravention of the European Convention. The effect of signing a 19(1)(b) statement is merely that the government considers that there is a no better than 50% prospect of the bill being found compliant with the Convention. And I can say this as someone who signed a Section 19(1)(b).
And I think in fairness, we've had a letter from the Lord Chancellor stating that that is his view.
So the short point is, as you understand it, the government says this bill is compliant with the Convention, but your view is to the contrary.
Well, I think if the government were so confident that it were compliant, then it wouldn't have tried to, as comprehensively as it has, remove opportunity for judicial scrutiny and oversight and disapply various aspects of the Human Rights Act. That I think at the end of the day, if a confident government that was sure of its position as it could be, wouldn't have tabled the bill in this form.
Right, I'm Helena, and then Bella, I'll bring you in. Helena, for our last question, I think Bella
This is about notwithstanding clauses, just to flag that up, and of course the general public wouldn't know what I'm talking about at all. But let's make it clear. According to the bill, the bill would apply notwithstanding contrary provisions in domestic and international law. So they're going to say this bill overrides that. And they include the Human Rights Act. That includes the Human Rights Act. Particularly, I want to refer to Section 6 of the Human Rights Act, which requires all public authorities to act compatibly with Convention rights. So what does it ultimately mean for the UK's compliance with the ECHR? Does disapplication of the HRA, of the Human Rights Act, in this bill have implications for the future of the Human Rights Act? What do you make of that?
I'm happy to kick off on that question
yes,
as well.
Please.
Thank you, Baroness Kennedy. So I think I started to make this point earlier in the fact that the bill is the latest attempt to exclude and whittle away rights and protections under the HRA, save notably Section 4, I think one of my colleagues noted. And the committee will recall, I'm sure, very well the so-called Bill of Rights and as I mentioned previously, the attempt to remove Section 3 from the Illegal Migration Act and the Victims and Prisoners Bill. And I think it's worth recalling again the fact that the whole point of the Human Rights Act was to ensure that human rights claims were decided with and dealt with in our own domestic courts to bring rights home, so to speak. And this approach has worked well. I think the independent review that the Ministry of Justice did, the consultation, in fact, the MOJ did back when they were considering the Bill of Rights, the response was overwhelmingly positive in terms of the functioning of the HRA and the lack of a need to reform it in any material sense. And this has led to a good track record in terms of UK compliance at Strasbourg. I think there are only 4 cases against the UK in 2022, with 2 finding violations, which is a small fraction of the overall caseload of the court. So that's that's the important context to have in mind. So if we've got a situation now where we have a legal framework which is helping for good compliance and helping public authorities think in a rights compliant manner, and then on the other hand we have this bill which says actually let's start removing those considerations or not having them as obligations on public authorities or not allowing courts to make interpretations with that respect, you're going to end up in a situation where you have more violations and more breaches and more appeals and cases going directly to Strasbourg at the additional cost, at the additional time, at the additional complication. And so you end up having a culture within the Home Office and other departments of undermining and reducing the kind of rights compliant culture that I think we should all aspire to have in our public bodies.
Thank you. Any others want to come in on this business about what the likely impact is on the Human Rights Act in the longer term when you see legislation being introduced that is going to basically override it?
Well, the Rwanda bill disapplies sections of the Human Rights Act in relation to legal immigration policy, but whether that applies to other areas of public policy or it could apply in the future, that's speculative. But sure, the bill does have implications in terms of managing the borders.
I mean, do you think it will erode that business of there being this overarching thing which protects individual?
That's a really interesting question, and it does sort of move outside of the topic. I would say, I'm quite libertarian in my outlook. I believe habeas corpus, the principle of double jeopardy, freedom of speech, freedom of association. I'm 100% in favour of that. But since the Human Rights Act was introduced in 1998, many of these basic liberties have been eroded. It hasn't protected those. If you look at
protection of victims, huge protection of victims.
I'm not saying it hasn't.
Victims of crime, victims of inhumanity, victims of abuses in many different circumstances.
I'm not saying.
Would you agree with me though on my statement about what it's done for victims?
I'm not saying it hasn't protected some people, but there are other liberties that perhaps it hasn't protected. And some people believe
Which ones are you saying those are?
Well, freedom of speech, for example.
Could I just query that? Because it's an issue that you and I might agree on, Dr. Jones, that some women in this country have suffered detriment in the workplace because as a result of their beliefs in the area of gender identity ideology. It's the courts of this country that have stopped those women from losing their jobs by virtue of utilising Article 9, freedom of belief, and Article 10. There's been a huge, and I find joyous, that's my personal view, explosion in the jurisprudence in this country on Article 9 and Article 10. So there's an example. I don't agree with you that the Human Rights Act isn't working to protect free speech. I think it's really been put to work in the last couple of years protecting free speech.
No, well, if you look at international indexes on censorship, we've actually gone down the rankings in terms of censorship. In terms
but my
of
point is that when people want to defend themselves against attacks on their belief or their speech, it's to the Human Rights Act that they turn. Is that not the case? I know we're going off at a tangent here, but I just wanted to challenge your assertion.
I'm playing devil's advocate here. There are people who argue that it hasn't protected some liberties, it has protected others. However, there's a trade-off between this legislation and controlling your borders. So people talk about the legislation as though trade-offs don't exist, but they do in the real world. And, many of the principles enshrined in the Human Rights Act may make it very difficult to maintain control over illegal immigration, detain and deport. So
equally, when this committee produced its report on the independent review of the Human Rights Act, they found that by and large it was working very well. They only recommended some tiny little tweaks, and this committee unanimously agreed with them. Now, that wasn't just the view of this committee and the view of an elitist panel. To their credit, despite the pandemic, the independent review of the Human Rights Act did some absolutely fantastic community engagement across the United Kingdom to get the views of ordinary people. We often as politicians get a row for using that phrase, ordinary people, but there was real community engagement to get the views of ordinary people on the Human Rights Act. And it was quite positive.
I think we're getting slightly off topic.
Yes, we are.
I am quite sort of...
I'm interested in the expression, trade-offs being necessary, and you're talking about the trade-off that is necessary to erode human rights in order to protect your borders. And it seems to me that you can do both. You can chew and walk at the same time.
Can we bring it back? It's been eroded.
The principle of non-refoulement, that makes it very, very difficult to deport people who come to this country illegally from outside of Europe because their countries of origin are deemed unsafe. And even if there's a slight possibility that they could be mistreated in some way, legally, it's very difficult to remove them from the country. Now, if you think...
We wouldn't want to, would we?
Well, if that's your view, that's fine. But there is a trade-off between obviously controlling one's borders and removing people who are here illegally, and obviously, following the word of the law in terms of the principle of non-refoulement. I'm just saying the trade-off exists.
I mean, going back to your original question, Baroness Kennedy, is this legislation that we're discussing today likely to overall send a message that human rights are less important, not more important, and erode a rights culture in the UK that the legislation, the human rights legislation, was very much about? And I think on balance there is absolutely a risk of that, because you have very senior politicians, including the Prime Minister, effectively saying there is one group of human beings who, whatever they've been through, don't have the right to protection in the UK. Whether they're victims of torture, whether they're victims of trafficking.
Sacrifice it by coming in a particular way.
Exactly. Mm-hmm. So they are, in effect, some kind of second-class global citizens that don't have legitimate rights to protection in the UK. And I think that inevitably does erode the perception of the importance and paramountcy of individual rights. And I agree with you that there should be no tension between legitimately wanting to control your borders, but at the same time recognizing that there are inalienable rights of individuals that need to be taken into account, that need to be given a fair hearing and due process. And I would actually argue that concept of granting people a fair hearing and due process are very British and go to the heart of British values within the UK, whether that's in terms of our unwritten constitution or the historical development of our legislature and our legal frameworks.
Thank you. I think I'm going to have to draw this panel to a close. I know Belle wanted to come in, but Helen, I wanted to make sure that you were happy.
That's fine.
Right. Belle.
Thank you. There are two main arguments that are always given about this bill and pushing it forward. One is that the individuals we're talking about are illegal, and the other is the amount of resources it takes this country to keep them. Can you confirm, and I think we've touched on this before, whether or not indeed under international law the people we're talking about are illegal, and actually whether or not there's been any sort of comprehensive assessment as to how many asylum seekers that this country could actually support?
It depends on how.
Well, I mean, I think as the Chair said very eloquently earlier on, that under international law the right to asylum is not illegal. It is a legitimate right to seek asylum in a country of an individual's choosing, and to put forward a protection claim and to have that claim heard with the right legal protections applied to it, and as part of that process to have your individual rights respected. There is nothing illegal about that, and indeed I would argue that broadly speaking, most prime ministers up to the recent few prime ministers, and there's been quite a few recently, have largely respected that right for an individual to come here and seek asylum and put forward a protection claim, and that should be continued today. That is the fundamental point about the convention, and as I would say, it's not outdated for a torture victim to come here and seek protection. On the point about asylum and whether we can afford to process individual asylum applications, well, we seem to be able to afford to grant £400 million to the Rwandan government without them looking at any individual asylum case. Of course we can afford to run an effective and efficient and value for money asylum system. We've been running an extremely ineffective and extremely costly asylum system through to poor management, through to poor political decisions and to poor political oversight. That is why the government has been spending millions of pounds a day on hotels. If we process cases efficiently, effectively fairly and based on good quality decision making, we wouldn't have had the backlog which would have led to the use of hotels. So we can absolutely afford to run an asylum system, and the vast majority of people that come here, seek asylum and become refugees, go on and stand on their own 2 feet. In fact, I would tell you, based on our work at the Refugee Council, that most people that come here as refugees, the idea of not being able to stand independently on your own 2 feet and pay your own way and to look after your family is deeply shameful, and they don't want to have to live off support from the state. They want to be able to stand on their own 2 feet, and the vast majority are incredibly entrepreneurial and go on and do that and contribute to communities right across the country.
Thank you. So just basically, just whether or not any of the assessments that are made in the general language that's used when talking about this bill are based on any sort of evidence at all.
I was just going to answer the point about illegality very briefly, to agree with the Chair and to say that Article 31.1 of the Refugee Convention is abundantly clear. Its purpose is to protect, not to exclude individuals who have breached immigration law and who are seeking protection or asylum in the UK. That is its purpose. Any good faith interpretation under the Vienna Convention of the Law of the Treaties would result in a protective interpretation of Article 31.1. So they are not illegal under international law.
I think I'm going to draw this panel to a close because it's gone on for quite a long time, but I think it's been a very useful exercise. We've covered a lot of ground, and I'm immensely grateful to all 4 witnesses for their time and their...
Well, 3 of them, and less said about Dr. Jones, the better, I suppose. What a bell tap. But yeah, I found that, watching it second time round, I found that really, really interesting. I thought, the young lady, she was brilliant, and Mr. Solomon took no nonsense from our Catherine May. She can say whatever she likes. She knew exactly what she was saying. But I just thoroughly found that fascinating, because the 2 Tories made themselves look incredibly ridiculous, didn't they? Both Jill Mortimer and Catherine May. But anyway, I hope you enjoyed this. This very interesting little select committee. I've just found these guys absolutely brilliant. Well, apart from Dr. Jones, and I get the feeling that our good friend Reagan Elite is doing a live stream as well. So I don't want to be cutting into his time. So what I will do is I will just leave it here, because as I know you'll be all desperate to go over and say hello to Reagan, and hopefully I'll see you over there then. So have a pleasant evening. Thanks for stopping by, and again, hopefully I'll get these live stream nonsense sorted out. But you know me, I'll still keep making a mess of it. But I do try. So what I will do is I shall leave the stream here and hopefully see you at Reagan Elite's stream. So